Welcome once again to Lehto's Law. Here's Steve Lehto.
Jake sent me a story I might not have otherwise caught because it was on Wisconsin Public Radio. Wisconsin. And Wisconsin's near Michigan, but there you go. Wisconsin Supreme Court overturns OWI, operating while impaired. Conviction of man who fell asleep at drive-thru. The man argued that police violated his Fourth Amendment rights. Sarah Lear wrote this. And here's the question. You know, people get arrested for drunk driving every day. But how is it that they came to interact with the police in the first place? And so quite often someone gets in an accident and the police show up and the person's stumbling around drunk. That's a pretty clear-cut one. But someone's driving erratically. They'll see that and pull the person over and maybe do an investigation. But here the guy fell asleep at a drive-thru. And that appears to be all he did. Keep in mind the drive-thru is on private property. And someone simply said he fell asleep at the drive-thru. And of course, there can be a variety of reasons you might have fallen asleep at the drive-thru. One being that you were very, very tired. Now, some people are going to say, Steve, if you're driving while tired, that can be dangerous. Oh, it can be. But it's not the same as operating while intoxicated or impaired. Plymouth police in Minnesota violated a man's rights against unreasonable search and seizure when they stopped him after he fell asleep at a drive-thru, according to Wisconsin Supreme Court. So the Wisconsin Supreme Court's weighed in on this. The appeals court had upheld his drunk driving conviction after he argued evidence from the traffic stop shouldn't be used, and the Tuesday Supreme Court decision reverses the lower court decision. In 2019, this predates COVID, a McDonald's employee called police after they saw the man fall asleep while passing through the drive-thru. An officer watched the man drive away normally and then pulled him over. And the officer said, well, I'm doing a welfare check. And by the way, I can't tell you how many times I've heard stories where somebody called and the police said, look, I saw a driver doing something wacky, and the police show up and get involved. So the police officer said here he's doing a welfare check because the guy fell asleep at the drive-thru. He might not be okay. For all we know, he might have passed out. He could have a medical condition. So when the officer approached him and asked for the information you get, the man did hand the officer the wrong insurance card, but told the police he was sleepy because he'd been working for 24 hours. Another policeman arrived as backup, and the two of them pulled his driving record, and they saw that he had prior convictions for operating under the influence. They then ordered him out of his truck and arrested him after he failed field sobriety tests. Now, as the ruling from 6 out of the 7 justices notes, police did not smell alcohol on him until after they ordered him out of the truck, and up until they ordered him out of the truck, they had no reason to believe that he might be intoxicated. Somebody had seen him fall asleep, and he said, yes, I'm very tired. I've been working for 24 hours. So the justices concluded the police lacked reasonable suspicion for pulling the man over. Now, here's the thing. Pulling him over after someone said, I saw him fall asleep behind the wheel, I'm not sure I'll buy that. However, when they pull him over and the guy goes, look, I'm really tired. I've been awake for 24 hours. And if he seems to be conversing normally at that point, I don't know you got the right to pull him out of the car. So the opinion says this temporary infringement on personal liberty must be supported by reasonable suspicion. That is, in view of the whole picture, whether a reasonable police officer would reasonably suspect that criminal activity is afoot. While reasonable suspicion doesn't demand much, it does demand more than a hunch. And that is all we see here. All it was a hunch. And they rejected the state's justification for extending the stop under what's known as the community caretaker doctrine. It is the idea that law enforcement kind of wears several hats, says a clinical professor at the University of Wisconsin Law School. One is monitoring and investigating crime and preventing crime, but also protecting people and property and doing welfare checks on people. The community caretaker exception allows enforcement to take action if they have a concern about the welfare of a person. So obviously, if the guy's falling asleep at the wheel, you're not sure, is he sleeping? Is he unconscious? Is he having some kind of medical episodes? That's why I said I've got no problem with the fact the police pulled him over. I got no problem with that. But when they pull him over and he has an explanation and his paperwork checks out, you let him go. Police were initially justified in pulling him over because of concern about his well-being, according to the majority opinion, but justices said police weren't justified in continuing the traffic stop after he appeared to be fine. And so I've had people ask, how long can a traffic stop be? The Supreme Court has never given a hardline number on this many minutes. Now, there have been cases where they've said, well, it was this many minutes and that made sense, or this many minutes and it didn't make sense. But they've often said that, it depends on the circumstances, but however much time is needed. So let's suppose they pull you over for speeding. Well, and they decide to write you a ticket. How long does it take to write that ticket? That's how long the stop should be. And if they unnecessarily prolong the stop, then there's a problem. So here they pull the guy over. They go, hey, look, we got a report that you fell asleep behind the wheel of the car. Guy goes, I'm really tired. I've been up for 24 hours. Okay, let's see your papers. Guy hands over license, registration, proof of insurance. Now, he did hand over the wrong proof of insurance. They go, is this right? Oh, no, I'm sorry. Here you go. Hand the stuff back to him. Why do we extend the stop now? Well, because we pulled his record, and he's got a record of drunk driving. Okay, don't get me wrong. The guy's record is bad. But does that mean that any time in the future that he gets pulled over, that they can extend that traffic stop? Because apparently not. So the officer doesn't notice anything that indicates a medical problem. He does not smell alcohol. The man's not slurring his speech. He gives a reasonable explanation for falling asleep at the drive-thru, and that is 24 hours of work. And so the court here says that once the officer's community caretaking concern is resolved, the justification for the seizure ends, and therefore it should have stopped at that point. And again, remember, their original argument is we were looking out for this guy. Well, you checked. He gave you an explanation. There you go. Now, one justice did dissent. She argued the state's highest court should never have agreed to take the case because it doesn't establish any new legal doctrine. And I hate to say this, but there is a justice who does not understand that they have two jobs. One job is to interpret the law and clarify things for people in the lower courts. And the other is to correct the mistakes of lower courts. So if she's saying this does not establish any new legal doctrine, then she should recognize that, oh, by the way, the doctrine was not applied properly here. We should fix this mistake. Over the past several decades, courts have been expanding the authority of police to detain people, despite the Fourth Amendment, says an associate professor at the University of Wisconsin Law School, different than the previous one I quoted. This week's ruling, however, appears to be an exception to that trend. That professor says if this is a signaling that courts are going to take a closer look at the Fourth, then that communicates to police departments that officers need to be a little more careful and think really about what they're going to stop someone for and questioning them. And so, I know a lot of people are going to comment on this video and say, but Steve, the guy was drunk apparently. Now, they don't give the blood alcohol content in the story. I don't know what it was. But that's not the point here. I understand that you're going to say, hey, Steve, the guy was drunk driving and he gets away with it. Yeah, police make mistakes all the time where they screw up on their jobs. But that doesn't mean that you go, well, the guy's guilty so we can ignore all his constitutional rights. Okay, first of all. And second of all, remember that if someone's driving down the road perfectly fine, ain't nothing wrong with how they're driving. You can't just pull them over because they got a bad driving record and go, well, the guy's got a bad driving record. And they pulled him out of the car, presumably because he had a bad driving record. That's it. They said the guy had a perfectly good explanation. His papers were in order. And then we checked his driving record. So we pulled him out of the car. Okay, one more time now. Why'd you pull him out of the car? Because of his driving record. So don't get me wrong. Don't get me wrong. I have nothing against the laws regarding drunk driving. I've got nothing against them being enforced. Okay? But once in a while, when the police overstep the rules that are there to protect us and they screw up, well, guess what? They screwed up. And that's what happens. So this guy gets off, but then again, it happened 5 years ago, and he's been dragged through the courts this entire time. And so that's the other crazy part about the story, is that he got pulled over in 2019. And here we are in, 23, 24, 25. It's time's flying by so fast. Who knows what year this is? But the Wisconsin Supreme Court, 6 out of 7, say that the man who fell asleep at the drive-thru, yeah, you can pull him over to check on him. If he appears to be okay, you got to let him go. You got to let him go. So, Jake, thanks for sending that from Wisconsin Public Radio. Sarah Lear wrote that. Wisconsin Supreme Court overturns OWI conviction of a man who fell asleep at the drive-thru at McDonald's. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you can't explain it to a 6-year-old, you don't understand it yourself.